Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at an excellent book on break clauses. It's something which many of us come across in practice. I found it very helpful to read this book. It's now in a second edition, but it's a very important book for anybody involved in this particular area of law in terms of the relationships between the parties when they enter agreements. The book's been written by Mark Warwick, Queen's Counsel, and Nicholas Trompeter. It's available from Jordan's both as a book and as an e-book, and Elizabeth and I talked about this book prior to the review being written, and our book review title is as follows: An often overlooked area of leases and contract law, so well explained by Warwick and Trompeter in their new second edition from Jordan's. Now we'll talk about the book in a minute. Let's have a look at it first of all. There it is. You can see what we've got. Nice blue cover at the front. It's a hardback. There's the spine, and then at the back you've got some very basic information about the authors, and then a little bit more information there about what's actually in the book. And it's also available electronically. You can see there as an e-book. Now the back of the book runs to 300 odd pages. There's the index. The index is by paragraph numbering. So when you're looking for things, bear in mind that you need the actual paragraph number is the actual reference, not a page number. Then you've got a number of appendices at the back. These are various very useful suggestions in terms of what we call pleadings. I still use those terms, in other words, the actual drafting. There's the front page, and then there's some basic information about the book and the foreword to the new second edition, which sets out what has changed. And in fact, it's Lord Newburgh who has written the information concerning the foreword to the second edition, the first edition from Kim Lewison. Now then we've got the author's actual preface itself as to what has changed. Then you've got the titles, the actual contents for the titles, details of each chapter running through. See a lot of detail here. Will be of great interest, I'm sure, to a wide range of people dealing with tenancies. You can see that the chapter headings clearly set out. You should be able to navigate the book very well. 20 chapters, and then a series of appendices, break clauses for the landlord, the tenant, and then claims and counterclaims and so forth. So it's basic, and in fact I do think this book would be quite helpful for litigants in person, because in many cases their clients are not going to have that much money. Table of cases, so they would have, if they've got a break clause and know how to use it when they've got their tenancy agreement, this is the book for them. There's the table of cases, then the table of statutes, then some SIs, and then after that you go straight into the nature of a break clause. A break clause is a type of option entitling a landlord or tenant unilaterally to determine a fixed term lease before the fixed term expires by the effluxion of time. You can see the structure, paragraph numbering, that's a definition, and then you've got the footnoting, and it runs all the way through, very similar, and then there's a lot of reference to case law and, of course, statutes. So an excellent book, and just what we want, in fact, in this particular area of property legislation, when, of course, break clauses can be very crucial concerning possession actions and all sorts of other types of dispute between parties. So what do we say about the book? Well, we say the authors of this esteemed work, Mark Warwick, Queen's Counsel, and Nicholas Trompeter, have undertaken a substantial rewrite of the text for the second edition. They comment that the blame for the increase in the large number of cases cited lies on their shoulders and not that of the judiciary. The trouble is, it means that the judges have been making different decisions. That's what it means. Anyway, we're very grateful to them for actually looking at it and producing this second edition. The value of the book is that the case law included here has tended, quote, to emphasise the importance of strict compliance with the conditions in a break clause and the content of the break notice, which can often be overlooked. Prominent among the authorities emphasising the importance of the careful drafting of a break notice is a decision in the leading authority of Simons Hearing Instruments Limited and Friends Life Limited 2014 in the Court of Appeal. Another most important topic which the authors have given its own chapter to is the recovery of overpaid rent and other sums, subject matter which often features of great importance when one first sees the client with a rent problem. Normally they've got real financial issues, as I'm sure many of you will know when they come, and they give you a bit of paper and you're still trying to find where the particular information is that you need. You get there in the end, but I think this book will help you, because sometimes there's some really rather interesting ways in which you can find break notices and break clauses. Now, in the decision by the Supreme Court in Marks and Spencer plc and BNP Paribas Services Trust Company Jersey Limited, which was in 2015, the decision is well covered by a consideration of the implication of a term as to the repayment of rent and detailed discussion of the main points arising from the case. And I do think that's important, because at the end of the day we have to rely on the interpretations which the courts and the judiciary right at the top make, so that we know where we're going. And of course it can be no surprise then that David, that's Lord Neuberger, writes in the foreword in the following way. He says, "It is striking, and to the uninitiated it may be surprising, that an apparently relatively niche topic such as break clauses in leases can provide enough in the way of legal problems and issues to justify a book running to over 300 pages and over 500 reported cases." Well, I'm glad he said that, because obviously it's not a big book, but it's an important area, and the case law is quite substantial, and it's nice to have it all in one place. So thank you very much to the two authors for doing that. As advisors and professionals will know, it's no surprise that break clauses in leases have given rise to so much difficulty, as Neuberger puts it. He goes on saying that experience shows that there is something about the landlord and tenant relationship generally that has a tendency to produce uncertainties, conflicts and disputes which require legal advice and often end up in court, in arbitration or in mediation. And that's where, of course, break clauses comes into its own as a leading statement on a very specific area of the law of leases, as well as clearly and brilliantly structured as a book which allows us, as the lawyer or the layman alike, as the litigant in person possibly, unrepresented party, to deal with the problem in hand. And the last word I think will be left to Lord Neuberger, as it's surely an excellent and much needed book, quote, which treats a difficult and significant topic very well, both academically and practically. And that's exactly what we want. Because at the end of the day, I'm not going to be talking academically to a judge when I want a particular type of order. But what I do need is the practicality of it. I want to go straight for the issues, especially when there are confusions, and it's quite possible that the party on the other side is unrepresented. Let me make a final point, and that is that the book is fundamental, I think, for your law library if you act in break clause cases, in other words, landlord and tenant and property matters, and it can often cover ancillary matters such as insolvency, assignment of stop or mistake, side agreements and unjust enrichment. So you've got a real mix there of all of the problems which you might be confronted with in a simple, what starts off as a simple county court action. We found this title the best short statement of break clauses available for practitioners and litigants in person today, and I'm very grateful to both authors for the work they've put in to give us what is a really good service in terms of advice and help in this often really quite problematic area, because you've got people really up against it who quite often need advice, and we need to get the right answers so that people aren't necessarily exploited. The law's stated as at the 25th of February 2016. So a quick look at the book again. There it is, front. It's not a big book, actually, really not a big book at all. He may say it's 300 pages and so on, but I think it's, for what it is very, very good value. You've got a lot of information. These are the appendices here. This is a break clause for the tenant, a break clause for the landlord. And then if we just open it in the middle, I'll just take it anywhere. Particular conditions in a tenant's break clause. And you've got quite a large number of cases. Mr. Justice Morgan, who will be known to many of you, making certain decisions in that particular case there. There are a whole range of cases. In fact, it is what I would describe as very case heavy. Here we have Chapter 11, the recovery of overpaid rent. It is case heavy. I wouldn't say it's over heavy at all, because there is in fact a lot of case law. You're not necessarily going to find all of it in this book either. So it's useful if you're doing a break clause case to have this book with you. Thank you anyway to Mark Warwick, Queen's Counsel, and Nicholas Trompeter, and of course to everybody at Jordan's for producing these excellent works for us. We do rely on you to give us this information. It makes our lives a lot easier, and it means we can get on with getting the right decisions and the right advocacy presented at the right time. So thank you to all concerned. Much appreciated for the work you do to help us. Bye bye.